President, please be seated. The court is now back in session. Per email sent to the parties by the senior legal officer on the 25th, 28th, and 30 September 2015, that this afternoon the trial chamber will hear observations and submissions by parties on three issues. The first is the request by the defense team for Nuon Chea for the chamber to hear an additional witness in relation to the Piantmo Dam work site, and that is pursuant to Rule 87.4 of the internal rules. I refer to document E368. And the second issue for discussion this afternoon is the observations from all parties in relation to the letter by the International Co-Investigating Judge regarding the proceeding to hear testimony of an expert, that is to TCE 95, before the trial chamber. That is document E367/1. And the third item is the disclosure of 11 documents from case 004 to case 002/02 by the International International Co-Prosecutor in relation to the treatment of JAM. That is document E319/33. Additionally, we'll hear the submission by Kiel Sampon defense team regarding certain matters. Let me now move on to the first item for our discussion this afternoon. And the chamber would like to ask the parties whether they wish to make their observation regarding the request by the defense team for Nuon Chea. And in order to clarify the matter, the chamber would like to hand the floor to the defense team for Nuon Chea to provide a brief summary of your request to hear an additional witness in relation to the Piantmo Dam work site. You can proceed, the counsel.
Thank you, Mr. President. I don't think I have actually that much to add to our request. I think it is argued why this particular witness is necessary to hear in relation to Piantmo Dam. I think he can potentially provide very interesting evidence as to structures, etc., at the dam, but of course also in relation to possible events in the Northwest Zone in more general terms. You know that we have confronted certain witnesses already with his testimony. So I think this particular witness is an important witness and should come to the courtroom to testify. So I think all our arguments are in here, so I have nothing really to add specifically. Thank you.
Thank you, counsel. And the chamber would like to give the floor to the co-prosecutors to make your observation or response to the request by the defense team for Nuon Chea on this said topic. You may proceed.
Thank you, Mr. President. I think I can be very brief. The prosecution does not oppose the defense request to hear this additional witness. Given the fact that his WRI and his DC-CAM statement are both already before the chamber, and given the fact that they've been used with a number of witnesses, we think it's a reasonable request. We think that perhaps the defense's primary point is the witnesses' evidence regarding what they would characterize as a planned rebellion In our submission, the written evidence that's now before the chamber is ambiguous and incomplete in that regard, and for that reason, we submit that it would be reasonable to call the additional witness. I would just add that we don't agree with the defense's characterization of his evidence on the conditions at the dam as being exculpatory. We would submit that the excerpts of his evidence they've selected are very narrow and don't accurately portray the whole of his evidence, and that his evidence regarding the conditions will ultimately be inculpatory. But I also believe that's a conversation that we can have at another time. So, in short, Your Honor, we don't oppose the defense's motion.
Thank you. And the lead co-lawyers for civil parties, do you wish to make an observation? Mr. President, the lead co-lawyers do not have any observation or oppose this request. Thank you. President, and I believe the defense team for Kiel Sampon does not have any objection to the request. If you have any, please take the floor.
No, Mr. President. We will rely on the Chamber's wisdom.
President, thank you. Thank you. And let me move to the second issue. That is in relation to the content of the letter by the International Co-Investigating Judge. Before we decide whether or how the hearing of the testimony of the expert through TCE 95 is to be organized, the Chamber wishes to hear opinions from the concerned parties. First, the Chamber would like to hand the floor to the co-prosecutors. You may proceed.
Thank you, Your Honors. Good afternoon to everyone. Your Honor, the co-prosecutors have read the letter from the International Co-Investigating Judge. We believe his request to have a legal officer present is reasonable. We understand that investigations are confidential not by his discretionary decision, but by law at the ECCC. I would say, though, that I don't anticipate that there should be a great problem with any disclosures of confidential information. The prosecution does not plan to ask the expert about what people said to OCIJ. Those records of interview are on the case file already, the relevant ones, and they speak for themselves. We will be asking the expert questions regarding the CHAM and what happened to them based on his work. He has written 2 books. He clearly has made many interviews outside of his work for the OCIJ. But I do think it's reasonable, the concern of the International Co-Investigating Judge, and because his concerns are reasonable, it would be advantageous, I believe, but up to Your Honors, to have a legal officer from that chamber present to bring to Your Honor's attention any concerns they have about disclosing confidential information.
Thank you. And the lead co-lawyers for civil parties, do you wish to make any observation or to give your opinion on the content of the letter of the International Co-Investigating Judge?
Thank you, Mr. President. We have no specific observations to make with regard to that letter, which we have read. So we will rely on the Chamber's wisdom regarding that issue.
Thank you. And the defense team for Nuon Chea, do you wish to make an observation regarding the content of that letter? That is in relation to the hearing of the testimony of TCE 95 in the very near future. that is in relation to this case.
Yes, thank you, Mr. President. We're not convinced yet that it is quite as simple as the prosecution is describing. Let me first say, of course, there are confidentiality issues in case 4. There's no dispute or discussion, I think, there. However, Mr. Osman is primarily here to come to testify as an expert. That is a personal obligation of him to the court. It's up to him, first of all, to decide whether he, when answering any questions, is violating certain procedural rules or certain confidentiality issues in the investigation. So I think all parties should be able to ask all the questions they would like to ask. It is then up to Mr. Osman to decide whether answering any such question would bring him into problems. And then it's up to you to decide whether he, in a particular instance, can indeed decline to answer. So it is there that potential problems might arise, obviously not in the questions that we are asking. Let me give you an example. Obviously, in our case, in this trial, we're talking about events at Wat Otakun, the pagoda. We all know that this particular pagoda is part of the investigation of case 4. If I would ask him in general terms about what he knows of, for instance, the command structure at Wat Otakun, he would potentially get into problems because this very same topic is being investigated right now. In theory, it might not seem problematic, but in practice, we could enter quickly a situation where there's all kinds of debates coming as to whether his answers are bound by ruled by the confidentiality restrictions or not. So the problem is that we are both dealing with the same investigations, or at least partially, that are being done in case 4. I think that should be resolved per question, but I'm not quite sure how, in this very simple example, things would go, because strictly speaking, he could answer, well, I cannot say anything about that, because technically he would be right, because that is part of case 4. But if it's such a broad formulation, then it will possibly end up in him not giving any answers, for instance, about what happened in Sector 41, or more particularly in Wat Otakun. In respect of the question whether someone should be sitting next to him, that is, I think, also not without problems. I think there is some comparable case law at the ICTY in which, in the appeal proceedings, I think it was in the Milosevic case, where 2 government officials were present in the courtroom while a witness was or while a witness was answering questions. The appeals chamber ruled that although there was no provision to do this, the trial chamber at that time was allowed to have government officials in the courtroom. But I don't think these government officials were allowed to intervene with the particular witness. They couldn't coach him, or they couldn't say that one question or the other question could be answered yes or no. Having said that, the question then arises whether Ms. Ewing, who is, I understand, a legal officer, is the one who should be entitled to be present and possibly to assist the expert. In my own jurisdiction, that would be typically, excuse me, a lawyer representing the witness who could advise the witness whether certain questions should be answered yes or no. I don't think, or maybe that is the case, but I'd be happy to hear that, whether Mrs. Ewing is in fact admitted to the Cambodian bar and allowed to advise the expert. I think that is something that we should find out, and the expert is sitting here at his personal title, and therefore I think if assisted by someone in the courtroom, it should be a lawyer allowed to practice in the courts of Cambodia. I think in theory it might not be problematic, but in practice it could be problematic. So I think we should have a debate on how exactly we should proceed with the expert, especially when it comes to issues in relation to Sector 41 or Watu Takun. Thank you.
Thank you, Mr. President. As far as we are concerned in the Kyosompon defense, there are two issues. So we understand the confidential nature of the investigation and the process, and at the same time, if the expert to TCE 95 was called by the chamber as an expert, is that the chamber believes that he has useful information regarding facts concerning the proceedings, and for Kyosompon as an accused person, these facts should be debated publicly without going into in camera, which is something exceptional. Now, regarding the interviews of this expert with a certain number of witnesses who testified before this chamber, there's no problem because all these interviews are part of the case file. Now, regarding the answers to other questions, such as what my colleague brought up in a more generic way, if the person is an expert, and if we consider that he has the level of an expert, he should, on his own, without the assistance of anyone, be able to determine what he is able to say or not to say. We are not referring here to any ordinary witness. If the chamber deemed that it's necessary to call him as an expert, and I'd like to remind you that the Kyosompon defense was anticipating these problems and did not want him to testify as an expert, but okay, the chamber's decision was taken. So in that case, he has to be treated as any expert, and therefore he should independently answer the questions without holding him by the hand, of course, by respecting his confidentiality obligations. If he's subjected to any, So as an expert, I believe, I don't think that he needs to be assisted. So having someone from the OCIJ in the room, in the courtroom, to follow more completely the proceedings is not a problem for us. But having this person intervene and having this person suggest to the expert to answer in one way or the other does not seem appropriate in a legal proceeding. So that is the Queue Sans Plan defense's position. So if he's coming as an expert, then he should testify as an expert, answering to the best of his knowledge. Of course, we're going to, while respecting, of course, his professional obligations. So this is how we understand the way this hearing should be organized. So what we are interested in is what is in the case file 02/2 regarding the facts that Queue Sans Plan is being accused of, and we hope to include other elements because we're referring here to elements so which he was a party to the investigation of. So we have other observations to make regarding the expert. I don't know if if Mr. President, you want me to make these observations now so that the party may respond, or do you want first to ask questions regarding what we have just said?
President, let me solve this issue one at a time. And Judge Friends, you have the floor.
I just want to make one comment. I don't expect the parties here to answer this question, but for me, frankly, it's not completely clear. If one reads the request, point A, it would appear that the investigating judge says he cannot be asked any questions gathered during 04 investigation under any circumstances. So no matter whether it's closed or open session, completely closed. While if one reads the paragraph above, it appears to indicate that it might be possible to ask him these questions in closed session, because it says if this will take place in open court, he will not be at liberty to disclose. So I think we might have to clarify actually what that means. Does he want to preclude any information under any circumstances that he considers confidential, or would he agree to such information being given in closed court? Yeah.
Honor, I believe it's my understanding of the letter that the defense seems to be misconstruing what Judge Bolender is asking the legal officer to do. It is not to represent Yasa Osman, the witness. It is to represent his office in making sure that confidential information from that investigation is not disclosed. Counsel's indicated that some complex issues could arise from his questioning about what can and cannot be disclosed. I don't believe the witness is a lawyer himself, and the judge in charge of the investigation is asked to have a lawyer from his office represent his office, not the witness. Clearly, it would be improper for any legal officer representing the judge to tell the witness how to answer a question. That would be wrong, not to give them information about how to answer, but she should be allowed to advise the court, Your Honors, about what types of questions would lead to violations of the confidentiality required in those investigations, or to confer, I believe, with the witness to determine if his answer would reveal confidential information, and then instruct him whether, or tell Your Honors whether or not he is permitted to give that answer. But again, he's not representing, or the legal officer would not be representing the witness. They're representing the office of the co-investigating judges.
If I may respond quickly, Mr. President. But in this courtroom, in case 002, the international co-investigating judge has no status. He is no party. He is someone, of course, that we're dealing with because of the statements that he's disclosing to us. But as such, his office has no standing in this courtroom. Following from that, any legal officer from his office has no status in this courtroom. Only lawyers, like for instance lawyers advising witnesses not to answer questions if that could incriminate themselves, the witnesses, these are parties or functionaries who actually have proper standing in this court. A legal officer representing an organ which doesn't have any standing in this court, I don't think is a proper way of proceeding. If I read the letter from the International Co-Investigating Judge, it says, should any questions arise regarding the proper scope of his testimony, this will permit him, the expert, to consult her, the legal officer, in the presence of the trial chamber and the parties. So not being his lawyer would cause a very unusual situation, I think. A representative or the office itself have no proper standing in case 002. So that's why I think we should be very precise in this respect. And if you were to decide that a legal officer has a functioning or can function in this court, we should be very clear as to what her position is. So I do think it is problematic.
Juste une précision pour...
I would like to clarify something, to say that apart from the submissions I've made, the case upon defense would like to remind the chamber that decision E319/7 as to the manner in which documents from an ongoing investigation should be used should also be applicable to the parties. And I can go into details in public session as to how we can proceed. This chamber had already set out a procedure for the use of documents from investigations. I suppose that the same measures should be applicable to the questions that will be put to the expert.
Merci, Monsieur le Président. Juste...
Thank you, Mr. President. I would like to make a brief remark.
The President, please hold on. Let's finish on the defense team. Counsel Kung Samon, you may proceed. Kung Samon. Yeah. Thank you, Mr. President. I would like to draw the chamber's attention and the party's attention to the request made by the International Co-Investigating Judge. I understand the endeavor of the investigating judge to maintain confidentiality of the other future cases other than case 002/02. I would like to draw the attention of the chamber to consider the publicity of the proceedings of this court balance of the right of my client as well as the accused in case 002/02, because we have the proceeding, the protective measures on the documents in case 003 and 004, and how to proceed to maintain confidentiality of the cases. So if there is any restriction in any manner, when such restrictions or that material restriction may affect the interest of my client, so it does not oblige us to follow the respect of confidentialities that may run in contradiction to the interests of my client, because we are here to represent the interests of our client. So if there is any dispute which the investigating judges has warned that we not raise any questions that might affect the interest of my client, that will hinder the ability of the defense to represent the interest of our client. There is no law to restrict the accused to abandon their legal interests in order to safeguard the confidentialities of something else. The President, the international lead co-lawyer for the civil party, you may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. The rule that I consider important is Rule 56 of the internal rules, which provides that investigations are confidential and that all persons participating in such investigations should observe confidentiality. So each person participating in investigations is therefore under a duty not to reveal any confidential information. So I agree with the Defense Counsel that it is up to Issa Osman to know what information comes under the category of confidential information which he cannot reveal. So as far as I'm concerned, there are two solutions open to the chamber. Either Issa Osman is assisted by counsel who would advise him on the scope of his duty of confidentiality and his contract before the OCIJ, and also to have a legal officer who would appear to represent the interests of the Office of Co-Investigating Judges. That would be proper. As for Mr. Issa Osman, he is under a duty to observe strict confidentiality, and it is his duty to define the parameters of his confidentiality.
What counsel said earlier is correct. There is some precedent of lawyers for outside organizations representing a witness, not the witness, excuse me, but representing, in this case, governments. I think counsel mentioned the Milosevic case. In these other tribunals, they have rules regarding national interests, that information that could compromise national interests can be provided to the court under certain circumstances and kept confidential. So in the Milosevic case, Wesley Clark, a general from the United States, and Ambassador Orkin, U.S. ambassador, testified with U.S. government representatives present to argue about the applicability of that rule, Rule 70, to limit his testimony. Also in the more recent case, in Stanisic case, the UK ambassador, I believe his name was Roberts, testified, and representatives of the government of the United Kingdom did not represent him. They represented his government in saying what information would be confidential that he could not be asked about or could not disclose. So it's exactly the same situation in this case. To ask the witness, a non-lawyer, to make those determinations, I think would be very unfair to him and to the Office of Co-Investigating Judges. Especially since we've heard from defense counsel just now that they anticipate that they may ask about confidential information and disclose it because it's in the interests of their client.
The President, Judge Jean-Marc Lavange, please, you may proceed.
Simple réaction.
Yes, I would like to react to what the sole party lead co-lawyers have stated. We have two solutions: either the witness is assisted by a lawyer, or we have someone representing the Office of Co-Investigating Judges. I do not see the point in having a lawyer present in the courtroom to advise Mr. Isa Osman, insofar as such a lawyer would not be a party to these proceedings, and that person cannot therefore discuss issues of confidentiality that could arise. I didn't quite understand something. Perhaps Counsel Giro could clarify what she was proposing, because I don't quite understand it. Your Honor, I am listening to you, and I realize that that wouldn't be a good solution, but I would like to remind the Chamber that it's a personal obligation of confidentiality, and it is up to the experts to determine whether the information and the questions that are asked would lead him to share with us information that he considers confidential.
One brief point, if you allow me, Mr. President, I would like to make. Both the civil party lawyer and Judge Lavergne are speaking of the Office of the Co-Investigating Judges. I don't think that is properly formulated. It's a request of only the international co-investigating judge. And you might think, well, does that matter? Well, possibly it might matter, especially in the light of a very recent decision, a decision that was released on last Friday in the case of Mia's Moot urgent request for a stay of execution of his arrest warrant. There's a very interesting paragraph in the opinion of the three national judges. Mia's Moot had asked for a stay of the execution of the arrest warrant, and had asked that to the pretrial chamber, and the pretrial chamber national judges said the following thing, and that's very interesting. The arrest warrant is a coercive measure to be enforced by judicial police to bring Mia's Moot before the international co-investigating judge alone, but not before both co-investigating judges. This measure in Cambodian society is regarded as humiliating and affecting Mia's Moot's honor, dignity, and rights substantially and irremediably. Now,
the President, can you explain the court what the ground for your intervention here, because we are now discussing on the issue of the legal officer at the Office of International Co-Investigating Judge and the documents that you are presenting to us. Can you please explain us first the reason and its annexes? How is it related to the methodology, particularly the that we did not hear the TCE 95, and now that we require that there is the presence of the legal officer of the International Co-Investigating Judge to assist in reminding or clarifying whether or not that should respond or not, and whether or not that relates to the confidentiality of the case.
I was getting to my point, Mr. President. It seems that the pretrial judges, the national pretrial judges, are making a distinction if a measure, coercive measure, or anything is coming from only the international co-investigating judges, rather than from both. Now, the reason I was standing up is that we are talking about a letter or request from only the international co-investigating judges. And if that is the case, it seems that national judges should react differently, possibly, to such requests. So I'm just making the observation that we're speaking about the office of the co-investigating judges, but that's not accurate. We're speaking about a request only of the international co-investigating judge. And a similar request from an international co-investigating judge was met by the national judges in case 4 as something, well, affecting the accused's right substantially and irremediably. So I think we should also maybe hear from the national co-prosecutor what the position is in relation to this request in respect of the expert only coming from the office of the international co-investigating judge.
The President, the national prosecutor, do you have any observation on this issue? Prosecutor. Mr. President, on this point, the national prosecutor has no comment. The President, Mr. Victor Kope, are you saying that this request is not valid and it should not be the subject of the discussion, and that this issue is acceptable? It's not on the issue of forms, but it is the substance that we discuss. Is that your position, that if it is admitted, it is not right procedurally, or what?
Well, it is our position when it comes to the request to summons 3 witnesses. We last week we filed our response, and we argued that the request from the international co-prosecutor was null and void and could not be entertained by the trial chamber. So it is our position in relation to that particular request. It will be our position in relation to the pending requests for disclosure and adding into evidence of certain case 4 disclosures. If it's our position here, I'm not entirely sure yet, because the decision is a bit ambiguous. But I think we can all agree that there is a problem, a legal problem, if there's only international co-investigating judge asking this and his national counterpart is completely silent. So I think it is a problem, yes.
I would just point out that the national co-investigating judge has consistently stressed the confidentiality of the investigation.
Mr. President, let us move to the other subject. Topic 3 for the chamber to arrange the scheduling order, particularly the scheduling for the hearing of the expert TCE 95 in the future. The chamber wishes to ask the international prosecutor whether or not you want to put more documents in addition to the recently put document such as document E /33 or not, and if so, what are the documents that you are likely to submit in relation to the treatment to the target group, in particular the JAM?
Thank you. Your Honors, from our review today, the status is that we have completed the review of all the written records of interview that are in English on the case 4 case file, and all of them that are related to the CHAM have been disclosed. There still are 27 records of interview that are in Khmer only that we are in the process of having reviewed with the limited staff that we have that can review those in Khmer. So I don't know whether or not they will be the subject of a disclosure motion or not. There also are 3 requests currently pending before the Office of the Co-Investigating Judges for disclosure of a few civil party applications. And we're awaiting, I would expect decisions soon, but we're awaiting those. But those are only civil party applications, not records of interview. And I would stress that we've taken to heart what Your Honor said about the prosecution being very limiting, using our discretion to be only only the most critical civil party applications for admission under 87.4. But these are being reviewed also for whether or not, of course, there's any exculpatory information. There still are, from my understanding today, about 400 applications, victim applications, civil party applications, that have not yet been reviewed, and those we would also review under the same criteria. Now, this is unless the defense is saying, and Your Honors wish us not to review those. If everyone doesn't want us to review those, I'm happy not to do that. It's a lot of work for us. But the current plan is to fulfill our obligations to the defense and the chamber and to continue to review those last 400 applications. We've reviewed about 1,300 applications already.
Can I just ask a supplementary question? I believe you mentioned 27 are currently under consideration. Is that correct?
There are 27 that are not in English. Yeah. They're in Khmer, and they're in the process of, which is much slower, of having those reviewed.
So, can you give me any indication as to if any of those will be disclosed, when this will be? And obviously they need to be translated because only in Khmer.
So, I mean, it would take some time. I don't know the answer to that, really. I'd be just guessing.
President, Councillor Victor Kopei, you may proceed.
Thank you, Mr. President. One remark. The documents that were disclosed yesterday contains a WRI of a witness considered to be very important, maybe the most important one. This witness was only interviewed a few weeks ago, or a month ago. This means that the investigation is ongoing as we speak. This means that it will not stop, obviously, with those 27 or the 7 from yesterday, but it will continue. And I think that is the crux of the problem. It will go on. even now as we speak.
And just for the record, of course, that is correct. The investigation goes on, so we continue to have them come in, these records of interview. I would say that we were behind, and we pretty much caught up to the backlog. So now we're dealing only with them as they come in, so it'll be a much faster turnaround.
À ce stade, Monsieur le Président.
At this stage, Mr. President, I am rising to my feet to say that we are waiting impatiently for your response to our motion. There will be limits that we have to take into account as this case presses on. And I note that we are giving time limits to the defense to study new documents, and it is important to bear in mind and to highlight the fact that these deadline extensions are not uncalled for. We ask for them in light of the disclosures that keep coming in. We still do not have access to the new documents that the co-prosecutor has referred to. A motion has been filed regarding disclosure of documents, but we do not have access to those documents. We also have the issue of timelines for the provision of these documents. So we are waiting for your decision. Since we cannot limit the influx of all these documents, since cases 003 and 4 are still being investigated.
The President, thank you. Now I hand over the floor to the defense team for Kilsampon to present the request that they made actually through email to the trial chamber. So you may now enlighten the chamber briefly and orally on this request.
Thank you, Mr. President. I'm going to start first with the issue of the expert we were speaking about earlier. I believe that the first request that we have is very logical. In the context of your first schedule, you programmed to have this expert testify at the very end once all of the people regarding the treatment of the Cham have testified for various reasons that regard scheduling issues. For example, a certain number of witnesses who are supposed to testify could not testify when expected. So I believe I understand that these witnesses are going to be called later. So my first request is, of course, to make sure that the expert can still testify after the testimony of the other witnesses, because a certain number of these witnesses have been interviewed by the experts, and in our cross-examination we would like to get back to these interviews and when the witnesses testify. So therefore it's logical that this expert, in fact, of course, testifies once all of the witnesses have testified before. Second point, which of course is connected to the first, which is that we have noted during the proceedings that there are a certain number of documents that we would like to submit to the expert, parts of the segments that we'd like to have him comment about, and given what's happening during the proceedings when we have to provide ERNs and all that, it takes time. We believe that in the Kilsampon defense that the 2 days that had initially been scheduled by the chamber, which would represent a half day of cross-examination for the Kilsampon team, 2 hours and 20 minutes approximately, would be too short to allow us to review within reasonable time the different documents and the different statements and the different points that we would like to discuss with the experts. So therefore, we wish so that we are not too rushed. We would like to have extra time. So we would like to ask the Chamber to consider giving us at least one extra session per party. I'm speaking on behalf of the Queue Defense. I don't know if it's the same idea for other parties, but just for practical reasons and for organizational reasons, the half day that we have been granted seems to be a little bit tight if we want to have a cross-examination which is substantial. So that is what the Queue Defense team has to say with regard to that specific question. So I don't know if you want to give the floor to the other parties first, or if you have any specific questions to put to me before I start discussing my next request.
The President, you may proceed to your second request.
Well, my second request is maybe a bit premature, but it is in reaction to the issue that I hadn't quite well understood when it was raised by Judge Fentz a few days ago during the hearing. That is to say, how much time the defense will need to prepare the appeal hearings. Because, as I understand, this was a concern of the Chamber in terms of scheduling. We still do not have a scheduling order before the SEC. We expect, based on unofficial correspondence, that these hearings will occur before the end of the year for sure, maybe mid-November, between mid-November and the end of November, and maybe even the beginning of December. I don't really know, because there's also a week of holidays. So we do not know exactly when these appeal hearings will take place, but we can give you a bracket of about 10 days. And we calculated that depending on the work that we will have to do, that we will need in our team, the defense lawyers, we will need 5 weeks without hearings to prepare these appeal hearings, which you know will be not only the time when we will present our appeal grounds, but also the only moment when we will be able to reply to the other parties, because there is no written response that has been scheduled or planned by the Supreme Court. So we will have, therefore, a lot of work to do in that regard. And furthermore, there is also the possibility, well, new witnesses have been heard, and therefore these new elements will be debated. Therefore, there is a chance that in these appeal hearings that other witnesses will be heard. So this is something that we have to take into consideration. So we calculated, because we can't be everywhere at the same time, that is, say, being here before this chamber and at the same time in our offices preparing our submissions, we know that this is going to be the last straight line before a decision that will have an impact on case 002. So it's important for all parties, but it's particular for the defense to have this time. So this is the elements I can provide to you. I do not know, in fact, right now, what's going to be the date that the Supreme Court is going to schedule, but in terms of duration, in terms of workload, I think 5 weeks is full-time for the co-lawyers is a reasonable expectation.
The President. I have one question for the Council for Kiew Sampon. I refer to your first request as for the times we want to put the question to the CA 95. According to you, it's rather short. So to you, what or how much time do you think is appropriate for you to put the question to this expert? Because generally, if you ask for extension of time, other parties might ask for the extension as well.
Yes, indeed. Well, this is why I'm making the demand ahead of time. For me, a minimum of 3 sessions would be necessary to cross-examine the expert. Instead of a half day, I would like to have 3 sessions instead of 2, 3.
The President. Thank you. How about the defense team for Nguyen Chia? Do you have any issues regarding this extension of time for putting question? No, rather the 5 weeks to prepare the submission, the closing submission in relation to the appeal and the decision of the Supreme Court chamber.
Thank you, Mr. President. We understood the request to be that as soon as there is an official scheduling order, that we should give our views as to how long preparation time should be. It's still unclear whether it is indeed between 10 and 20 November or maybe even the first 2 weeks of December. I think that is now maybe debated at the Supreme Court chamber. Having said that, I do not think the request of the Kiew Samphan team to ask for 5 weeks is unreasonable. As you know, the appeal is extensive. There's a lot of preparation to do. As you know, we've been fully busy with case 2.2. We've been flooded with case 3 and 4 documents, so we have been working, as argued last week or 2 weeks ago, almost non-stop. So I would argue that the requested time is not unreasonable. But we haven't come up with a final position yet because, as I said, we understood your request to be that as soon as there's a scheduling order, that we would then come up with our views.
President, thank you, and thank you to all parties for your observations and comments on the various issues that the Chamber has considered the challenges we are facing. And now the International Co-Prosecutor, you may proceed.
Yes, thank you, Mr. President. I was just waiting to make some very brief comments on the submissions of the Kiew Samphan team. First, we would agree with the Nguyen Chia team that it's premature at the moment to even talk about the time necessary to prepare appeal because we don't have neither a date from the Supreme Court nor an indication of the format, how many days hearings that will be, and whether the Supreme Court is going to limit the parties to specific issues to talk about, which I would hope that they would because there's somewhere between 300 and 400 grounds of appeal. So we think it's premature to talk about time for preparation. As far as the time allotted to the expert on the CHAM, we do think 2 days is more than sufficient, that that's sufficient time. But I do concur with Council's proposal that the Chamber, it would be more efficient to have the expert testify at the end of the segment after the other witnesses. I think that makes sense.
Thank you. the chamber will take this issue into deliberations, and we will sort out this issue. Any issues that we can resolve it immediately, we will do it, and others we will address them in due course. So the hearing today is coming to a conclusion. The chamber shall adjourn now and resume on the 5th of October, on Monday next week, and chamber shall hear 2 TCW 950, and there are 2 TCW 904 as a reserve witness after 2 TCW 950. So this is the notice to all the chamber, all the parties and members of the public.
No hearing tomorrow.
The President, no, there is no hearing toward the end of this week, because we do not have any individuals whom we can hear, because those individuals are not available for the hearing. The security guards are now instructed to bring the 2 co-accused back to the detention facility and have them back in this courtroom on the 5th of October, that is Monday, before 9 a.m. The court is now adjourned.